scalpel back in. All right, we're back online. We left off at House Bill 315.
So there is a sponsor amendment, or a sponsor of the Senate cross-file amendment. This would make the member of the task force who has to be a judge of a circuit court that sits as the orphans court in that jurisdiction, that is now a non-voting member, and then it's changing the people responsible for staffing the task force from the Administrative Office of the Courts to the Department of Legislative Services in conjunction with the Maryland State Bar Association.
Okay. You want to move the amendment?
I'll move the amendment.
All right. All right, is there a second? Second. All right, second. Everyone okay adopting the amendment? All right, now the bill is before you as amended. Is there a motion? All right. This motion seconded. Is everyone okay being recorded in the affirmative on the amended bill? All right, House Bill 315 with the amendments passes unanimously. All right, we're now going to go on to House Bill 516.
House Bill 516 is a cross-bill to Senate Bill 381, which passed the Senate. The bill generally prohibits an agency from accessing or using recorded images or associated data from automated enforcement systems without a warrant, subpoena, or court order, unless the access or use is for an appropriate traffic enforcement purpose, subject to certain exceptions. So the bill is nearly identical to the bill that was passed by the Senate. The only difference is on page 6, line 15. In the permissible uses of this data, the House inserted in the phrase to administer and process citations. And my understanding of that is it was suggested by some of the contractors who do this work, and they were concerned that without that, they might be unable under the bill to do their normal work. So that is the only difference between the House bill and the Senate bill.
Motions for a favorable. They have the Senate bill. This is House Bill 516.
And unanimous in committee.
All right.
You're welcome.
House Bill 516 passes unanimously. All right, we're going to go on to House Bill 445.
5 prohibits a person from committing a violation of 7302 of the criminal law article, which is unauthorized access to computers and related material with either the intent to interrupt or impair the functioning of a public safety or answering point or PSAP, or a violation that does interrupt or impair the functioning of a PSAP. The bill imposes separate penalties for these violations. A violation that is merely intended to interrupt or impair the functioning is a felony punishable by imprisonment of up to 5 years and a maximum fine of $25,000. A person who commits that act and does in fact interrupt or impair the PSAP is also guilty of a felony, but that is punishable by imprisonment of up to 10 years and or a $50,000 fine.
All right, let's go on. Go ahead.
All right, I'd like to conform it to the Senate bill, which addressed the penalties and the like.
Motions conform to what we did in the Senate. Is everyone okay being recorded in the affirmative? Was that a unanimous vote? It was unanimous. All right. Unanimous vote. Is everyone okay being recorded in the affirmative on that? Same vote? That is,
House Bill 445. House Bill 445.
all right, let's go do House Bill 347.
House Bill 347 is the cross-file Senate Bill 150, which the Senate has passed. Generally alters statutory provisions relating to the filing and maintenance and transmittal of land records. The House version before you does have some differences to the Senate version. It alters the definition of land record to say that it's any document recorded by a clerk of the circuit court relating to property, instead of saying affecting the title of the property. And the Senate version had a provision that would not hold the clerk liable if a document is not recorded correctly due to not following these requirements. That's not in this version of the bill. And it also requires the clerk to index a release or partial release of a mortgage just like it does for a deed of trust. There is an amendment in your packet that makes a further technical change. Altogether, this is what was worked out between the sponsors and what the advocates actually wanted, who are doing all this sorts of recordation. The House version.
Okay,
It's just literally 3 words. That's taking out a bracket.
okay,
It's a technical fix.
which is fine. So is everyone okay adopting the technical amendment before you? All right, great. Now the bill is before you as amended. We are not in possession, we passed this one, right? So we passed this one out.
Yes.
All right. I assume the House is going to conform, okay. All right, so the motion's for favorable.
Second.
Is everyone okay being recorded in the affirmative? All right. House Bill 347 passes unanimously. I'm going to go to House Bill 528.
House Bill 528 is the cross-file to Senate Bill 915. The two bills are substantively identical, however, the amendments to them were drafted in a somewhat different grammatical style. I talked to counsel over in the House, and we agreed the Senate version is probably superior, and my understanding is a delegation met to vote to conform the House bill to the Senate bill. So the bills specify that for 3 years after the effective date of the bills, that a person may not violate any provision of the vehicle laws on a private roadway within Queen Anne's Village in Baltimore County. It authorizes police to enforce the vehicle laws on those roadways. And finally, it requires the Baltimore County Police Department to report on the implementation of the bill. So the motion would be to conform the House bill to the Senate bill, which is, they're substantively the same, but the grammar of the amendments was a little bit different.
Motion? All right. The senator from Baltimore County makes a motion to conform it to the Senate bill. All right, it's been seconded.
So Senator Holden had abstained, Senator G. But it was unanimous on the floor.
All right, it's passed unanimously on the floor. Is motion for a favorable with the amendment? Second, is everyone okay being recorded in the affirmative? All right, House Bill 528 passes unanimously with the amendment. All right, Josh, this is you again as well. This is House Bill 579. Did they collapse their two bills, or they put in,
Yeah, so it's.
so I would just do the two, what we did?
Just,
conform
make
to-
it.
Yeah.
So House Bill 579 is the cross-file of Senate Bill 608, which the Senate passed in a slightly different posture. The bills make changes to the process for U visa petitions. Among other provisions, they expand the list of people who may request certification under a U visa. They deal with the timeframes by which certifications must be issued or denied and when they can be applied for. So the major differences between the two versions of the bills are that the House bill includes provisions which were, my understanding is they came out of the sensitive locations bill, which the Senate dealt with in a separate bill. Those provisions are not the same as those that are in the Senate bill. They're slightly different. The timelines by which a certifying entity must act on a petition are slightly different between the two bills, and they have slightly different language. So the Senate bill made an amendment. Both bills as drafted referred to there being no statute of limitations on certification requests. The Senate reworded that to essentially say you couldn't deny them based solely on the amount of time that had passed. The House bill kept that language as it was originally drafted. So those are the major differences between the two bills.
This is a motion to conform to the Senate bill. Is there a second? Yep, good.
I'm confused.
So the House bill collapsed in sensitive locations with the U visa process. We did two separate bills.
I know, I think I voted for this one in the Senate against the sensitive locations. So now we're collapsing the two together, which makes it a quandary.
The House put their version of the sensitive locations bill into the U visa bill. And I think the motion would be to conform to the Senate bill, so this bill would not have the sensitive
Oh, fine.
locations part.
Oh, I'm sorry. I misunderstood. That's fine.
Nine to 11.
All right, House Bill 579 as amended passes, what, 92?
Yeah.
All right, we're gonna hold this one. Right?
604?
Yeah.
Yeah, well, OAG had just sort of awarded us the judiciary's letter of concern.
All right. House Bill 616. So House Bill 604, which is the first one on this list, there's some ongoing dialogue with the Attorney General's office and also the courts. We're going to hold it just to work on it a little bit more. And then House Bill 610, the cross-file we referred to summer study. So we're just going to hold the bill since the cross-file bill is already referred to summer study on the Senate side. So we're going to move to Senate. Yeah, that was House Bill 610. Yeah. Okay, so we're just going to hold it then. And then House Bill 616.
House Bill 616 expands the prohibitions under 10404A of the criminal law article to prohibit a person from willfully destroying, damaging, defacing, or removing landscaping or part of the grounds of a cemetery. Correspondingly, the bill expands an existing statutory exception to the prohibitions under 10404A to allow for removal of landscaping from a cemetery or burial site for the purpose of repair or replacement. Violators are guilty of a misdemeanor subject to existing penalties of up to 5 years and/or a maximum fine of $10,000. The bill also extends the statute of limitations to prosecute a person for violating these provisions under 10404A or B from within 1 year after the offense was committed to instead be within 3 years after local authorities in fact knew or reasonably should have known of the alleged violation. This is different than the language that the Senate passed. Specifically, that's with respect to the prohibition. The Senate version provided instead that a person may not willfully destroy, damage, deface, or remove, in addition to the existing list of cemetery objects, would provide a catch-all that says any other part of the grounds of a cemetery. It also made a corresponding change to the exceptions. Otherwise, the bills are the same.
Senator McKay.
You struck landscaping in the Senate version, right?
Do you want to just conform to the Senate bill?
You can, yeah, I'm supposed to have the hearing
Okay.
2 hours ago.
Yeah. I know. They're still on the floor.
Yeah.
All right. So the motion's conform to the Senate bill. Is there a
I'll
second?
share the good news at 8 o'clock tonight.
All right. Yeah, I know, right? All right. Motion's conform. Everyone's okay with that motion? Motion's for favorable. Is there a second? Second. Is everyone okay being recorded in the affirmative? All right. House Bill 616 passes with the amendment. All right, now we're going to go to House Bill 646.
It's held.
No, we held it, yeah, and then we held House Bill 610. We referred that to summer study only because there was testimony that another jurisdiction apart from Prince George, so it was Baltimore City, was also involved, and the problem may have been more pervasive in that. On 604? On 610. Okay. So we're going to do it summer study, but I think we can actually fix this. I mean, we'll come back next year and we'll definitely pass it, but there's, all right. And then now, so now we are now on House Bill 646. All right, we're going to hold that. Do we? Okay. All right. So now we're going to go on to then House Bill 755. We held it. There's an amendment being negotiated, added on in both the House and the Senate. We just want to make sure that we're doing the same amendment and that they're actually going to do it. So I want to make sure that we're moving at the same time. But no, they just passed it clean. I don't think they knew. I don't know if they knew about the other jurisdiction. All right. So we're now back on to. We're back on to House Bill 755.
House Bill 755 is a cross-file to Senate Bill 540, which the Senate passed. This prohibits a common ownership community from requiring certain sensitive information from a member, owner, or occupant as a condition of accessing or using a recreational common area. The only difference between this version and the Senate version is that the House version adds to the list of sensitive information medical records. My understanding is the sponsors agreed to this, and this is what the House will be conforming to.
All right. So then the motion is for favorable. Is everyone okay? Is there a second? Is everyone okay being recorded in the affirmative? All right. Yes, sorry, Senator Love.
I'm sorry. They also amended the definition of sensitive information in the corporations and associations article, and I just briefly wanted to take a look at that. Can we just hold it till the end of this calendar and I can, thanks, or this voting list or
Yeah, it's
whatever,
fine.
thank
We'll hold,
you.
yeah, we'll hold it for a little bit so you
Thank
can
you.
get clarification. So we got clarification from the Office of the Attorney General on the single subject inquiry on Senate Bill, not, on House Bill, sorry, the cross files 925, but 413. So I'd like to jump back over to House Bill 413.
I need a second because I have to,
All
it's
right.
a different list.
She's gonna. 413. It's on the prior list. We have the, so there was a question about single subject. He said it does not clearly, go ahead, you read it.
So the inquiry was whether these pieces of legislation may violate the single subject rule. The response from the General Assembly's Legislative Council from OAG was that they did not, we think it does not clearly violate the single subject rule. And that, I just want to sort of give an explanation for why that is generally framed that way. When OAG goes to advise the governor on the constitutionality of bills, the test that they are generally applying is whether it is clearly violative of the Constitution. So I just want to sort of explain that that's why that language is used.
Chris, come on, you remember this when we were discussing the Child Victims Act and the letters had the same language. And you remember, I'm ready to move on it, but motions for a favorable. Seconded. We can do a roll call? Okay.
Vice Chair Wildstreicher.
Yes, on the,
Senator
Yes.
Sidnor. Oh, sorry. Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden.
Yes.
Senator James.
yes.
Senator Henson.
No, and I'd like to just briefly explain my vote. There are many parts of the bill that I think have a lot of value and are completely in line with the work that we've done on criminal justice reform to give second opportunities. We did legalize cannabis, and I feel like that work is reflected in this bill as well. But I think where the bill takes a turn that loses my support is putting the felony designation for theft of a firearm. Typically, our theft statutes deal with the value of property, and this would be very unique. There are other instruments that could be used to harm people, and we don't put that designation of it being a felony to steal it because it could be used to harm someone. So what we're doing is very unique to firearms, and I would have loved to have seen this been a standalone bill so we could really flesh that out and have that debate in full without some of the other parts of the bill that may garner support speaking a little bit louder. So with that, I'll have to vote no.
Senator Love.
Yes.
Senator McKay.
No.
Senator Charles.
Yes.
Chairman Smith.
Yes. Yes. So, all right, what is it was
9-2.
9-2. All right, so last year, it got over into the House. It was on the House. And you'll remember that there was, I think, was it odor that it got stuck behind? Was it odor?
I can't remember. Odor was a couple of years ago.
Was it odor? No. What was
It
it?
was 2 years ago.
It was 2 years ago.
Yeah.
Was it odor? It got stuck behind odor on Sine Die.
Years ago.
So it got stuck behind, do you remember odor is a pretext for stopping people? So that passed. It was in the House. But this was last year, wasn't it? It was last year. Sure, I mean, we can, all right, so. All right, so we got, it's Senate Bill 925, which is the cross-file of House Bill 413. I'd like to move that bill as well. Same vote, is everyone okay? All right, great. Thank you, Senator West, for your,
Is it, we don't need to conform it or anything?
no, it's exactly the same. Thank you so much, Senator West.
Holden was down.
Oh, he was up. McKay was down. No. House Bill 788.
House Bill 788 is the cross-file to Senate Bill 619, which was passed by the Senate. This is a proposed constitutional amendment which authorizes the chair of the Commission on Judicial Disabilities to recall a former member to serve as a temporary substitute member or request that the governor appoint a temporary substitute member or extend a current member's term if a member is recused or disqualified or the member's term expires without replacement. The temporary substitute member is subject to the same qualifications as a normal member and must be a member of the bar in good standing if they are a judge or an attorney. That is the difference between the House bill and the Senate bill that was passed. The Senate bill just said any of the temporary substitute members have to be a judge or an attorney in good standing with Maryland State Bar, because if you look at the top of page 4, there is some of the members, 5 of the members are required to not be judges or attorneys. So if it was left how the Senate passed it, this would now require that those would be filled.
All right, so we should take the House version. Let's just pass, yeah, I think they're going to conform our
Yes.
version anyway, so let's just move favorable on this. Second, is everyone okay being recorded in the affirmative? All right, House Bill 788 passes unanimously. Now we'll go to, oh, yes. Senator Les, are we ready to go back to 755? Okay, House Bill 755. No, I think we're good. So we'll just do the motion for a favorable. Is everyone okay being recorded in the affirmative? All right, House Bill 755 passes unanimously. Now move on to House Bill 809.
Go ahead.
We just took the House version because the membership didn't make sense.
House Bill 809 authorizes an individual enrolled in an accredited institution of higher education or vocational training program to return to an out-of-home placement provider with whom the individual was previously placed under certain circumstances. The bill is nearly identical to Senate Bill 765. However, there is a typo in the House bill. On page 2, line 16, it should say subject to subsection B, but it says subsect to subsection B, so committee might want to, to fix the typo and that therefore conform it to the Senate bill.
I know, right? It's fine. Motion to conform. All right, is that okay? All right. Is everyone okay being recorded in the affirmative on that? Okay. House Bill 809 passes unanimously with the amendment. All right, now go on to House Bill 796. That's John again.
House Bill 796 is the cross-file to Senate Bill 566, which the Senate passed. It increases from $300 to $450 the filing fee for an order to docket or a complaint for foreclosure of a mortgage or deed of trust. It's in the same posture.
Increase the filing fee. Senator McKay and I were on the work group, and we compromised that instead of a $300 increase, it's only a $150 increase. So the two of us voted for the bill, both in committee and on the floor. I think Senators Folden, and James voted against the bill, if memory is correct.
But the House bill did,
796.
but the House did what we did, right? So it's the same?
This is the same thing that the Senate passed. Same exact thing.
Okay. All right. So the motion's for a favorable. It's been seconded. Is everyone okay? Just, you want it the same posture as the cross file? All right. Yeah, it's the same. All right.
One more bill on this list.
We'll now move on to House Bill 1152.
Okay, House Bill 1152 is the cross-file to Senate Bill 896. This was about the pet policy, for landlords to put it on their website and other places. There's an amendment in your packet. This would conform it to the Senate bill. In addition, it says that the website requirement is only if applicable, so only if the landlord has the website. This was a sponsor amendment, so my understanding this is what the House is going to do as well. So just to be clear, this is conforming to the Senate with the addition of saying if applicable in regards to the website requirement.
Thank you, Mr. Chair. This is the conversation that we had in committee and on the floor. It was never the intent for a landlord to have to do a website. It was, if they have it, then put it on. If they don't, they don't, and that just makes that clear.
Amendment's been moved. Now the bill is before you as amended. Motion is for favorable with the amendment. Second, is everyone okay being recorded in the affirmative? All right. Folden is down.
Folden's down?
Yeah. All right. House Bill 1152 passes 10 to 1. Okay. All right.
All right, see you tomorrow. I can say.
All right, so that completes the voting session for today. We're going to gavel back in 2 minutes for our bill hearings.
2 minutes.